Hi, everyone, and thank you for joining us today. I'm Nia Evans from the National Women's Law Center, and I am the organizer for today's webinar, representing student survivors of sexual harassment in court. We just have a few technical notes before we begin the presentation. All lines will be on mute during today's webinar. We will be taking questions after our experts are finished with the presentation, but we encourage you to submit questions throughout the webinar. You can submit a question by typing it into the designated area on your control panel and hitting send. We will be recording today's webinar, and you will receive a link to a recording of the presentation as well as a link to the PowerPoint slides within the next few days. At this point, I'll turn it over to Alexandra Brodsky, our Skadden Fellow at the National Women's Law Center. Alexandra, take it away.
Hi, everyone. We're so thrilled to have you all joining us today. Just to give you a quick rundown, I'm going to introduce our wonderful presenters, tell you a little bit about their background. But first, before she gets to run, our Director for Education, Nina Chaudhry, just wants to welcome everyone quickly and talk about our broader efforts in this area.
Thank you, Alexandra. Welcome, everybody, and thank you for joining us. I just wanted to mention that we are so thrilled to have everybody join to hear from our wonderful panelists. And as a tiny bit of background, the National Women's Law Center has been working on Title IX issues for 45 years now, including in the area of sexual harassment and assault, where we helped on the Davis case that set the legal standards in this case back in the late 90s. And we are growing our attorney network right now. And we are excited to have new attorneys join to represent students who are facing discrimination. Sorry, there's a little bit of an echo, so I'm just, it's slowing me up a bit. But anyway, and we're excited to have people join that network, and we'll be sending an email after this webinar so that those of you who may want to join the attorney network that we're growing can do so. So I just wanted to say that we have worked with Adele and Carrie for a long time, Adele for many, many years, and Carrie more recently, and they are wonderful attorneys, and we're just so pleased that they've agreed to do this training today. And I'm going to turn it back over to Alexandra to give you a little more detail about them.
Hi, everyone. This is Alexandra again. So first, Adele Kimmel is a senior attorney at the DC headquarters of Public Justice. Since joining the firm in '94, Adele has worked on a wide range of civil rights cases representing prisoners and immigrant detainees who were beaten, sexually assaulted, denied adequate medical care, and killed, women intercollegiate athletes seeking to reinstate their wrongfully eliminated teams, coaches of female interscholastic and intercollegiate sports who were fired in retaliation for voicing concerns about gender inequities in their school's athletic programs, students who were denied athletic scholarships based on their race, women who hit the glass ceiling of their workplaces, employees who were denied promotions based on their race, student survivors of campus sexual assault whose schools denied them equal access to educational opportunities, and students whose schools failed to protect them from bullying by their peers. I also just want to highlight Adele wrote an amazing article for the Yale Law Journal this past year about Title IX's protections for LGBT students, and while that won't be the focus of our conversation today, I encourage you all to check it out. Our second presenter is Carrie Simon, who works at the Fierberg National Law Group, which specializes in sexual violence in schools. Carrie graduated from Harvard Law School cum laude. She was the president of the Harvard Women's Law Association and co-editor-in-chief of the Harvard Journal on Law and Gender. Following law school, Carrie clerked for Judge Morgan Kristen of the Ninth Circuit and then served as the inaugural fellow at the Harvard Law School Gender Program, where she represented victims of campus sexual assault in the Title IX context. For several years prior to law school, Carrie worked on Capitol Hill, including as the director of the Congressional Victims' Rights Caucus. Okay, so I'm excited to join all of you in learning more about representing student survivors of sexual harassment in court. So Carrie and Adele, take it away.
Thanks so much, Alexandra. This is Adele, and thank you to the National Women's Law Center for organizing this webinar series, and even more important, for putting together a network of volunteers to make sure that survivors get the legal assistance that they need. Carrie and I are really honored to be part of this today. As Alexandra mentioned, Carrie and I are going to talk with you today about representing student survivors of sexual harassment in civil litigation. This is a pretty broad topic, so I want to make clear from the outset that we won't be able to dive into details on some issues, but want to make sure you get a good overview of the basics. Carrie and I will be focusing mostly on civil litigation against schools and school officials. We'll also be focusing more on sexual violence and other forms of sexual harassment, but we'll talk a little bit about other forms of sexual harassment too. Next slide, please. Our goal today is to cover the basics, the various causes of action and remedies available to student survivors under federal and state law. This includes federal civil rights claims for violating Title IX or the U.S. Constitution, and it also includes civil rights claims under state anti-discrimination laws and state constitutions, as well as tort claims under state law. Because the state law claims vary a great deal from state to state, we can't do a deep dive on those issues, but we'll flag what you should be looking for. Our main focus today will be on civil litigation under Title IX, which is the primary federal claim available to student survivors of sexual harassment. So let's talk about Title IX. Next slide, please. Title IX was passed as part of the Education Amendments of 1972 and prohibits sex discrimination in education programs. Most, if not all of you, have heard of Title IX, and many people, including some lawyers, think that Title IX is a law about ensuring equal opportunity for girls and young women to participate in school sports. That's partly right, but Title IX's prohibition against sex discrimination is very broad, and it covers a lot more than sports. So let's take a quick look at the language of the statute. Under Title IX, no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. Title IX prohibits all forms of sex discrimination in any educational program that receives federal funding. So let's break this down a bit. What counts as an educational program that receives federal funding? Next slide, please. Every public elementary and secondary school in this country is covered by Title IX because all public K through 12 school districts get some form of federal funding. Some private and parochial schools are also covered by Title IX because they get federal money too. So for example, some of these K through 12 private and parochial schools participate in the federal free lunch program. And under Title IX, if any school program gets federal money, then all of the operations of the school are subject to Title IX. Title IX's coverage is not limited to the specific program that gets federal funds. As for institutions of higher education, Title IX applies to virtually every university and college. It applies to, all state colleges and universities. And it also applies to nearly every private college and university because virtually all of them get some form of federal funding, such as through student loan programs. So as you can see, Title IX covers a wide range of educational institutions in this country. So let's turn to the meat of Title IX. Next slide, please. What counts as discrimination on the basis of sex under Title IX? The good news is that Title IX has been interpreted very broadly, especially in the last several years. Title IX protects females and males alike and prohibits all forms of sex discrimination. In simple terms, Title IX covers a wide range of conduct that creates a hostile educational environment based on sex. It's not limited to sex discrimination in academic programs or athletics. Just like Title VII's prohibition against sex discrimination in employment covers sexual harassment, Title IX's prohibition against sex discrimination in education prohibits sexual harassment. Title IX also applies to sexual violence, which is an extreme form of sexual harassment. Sexual violence includes rape, sexual assault, sexual battery, and sexual coercion. Title IX's prohibition against sex discrimination also includes gender-based harassment that isn't necessarily sexual in nature. So, for example, it includes harassment based on sex stereotyping. In other words, when a student is harassed because she or he doesn't conform to stereotypes about how people think girls or boys are supposed to look or act. LGBT students, lesbian, gay, bisexual, and transgender students are often harassed for this reason. So even though Title IX doesn't expressly prohibit discrimination based on sexual orientation or gender identity or expression, when students are harassed for being LGBT or perceived as LGBT, they may also have a Title IX claim. Another important aspect of Title IX is that it applies whether the perpetrator and victim are of the opposite sex or the same sex. So Title IX covers male on female sexual harassment, male on male sexual harassment, and female on female sexual harassment. And this is true whether the harassment is perpetrated by another student, a teacher, a coach, or any school employee. And it can sometimes apply to harassment of a student by third parties, such as when they're invited on campus by the school. Okay, now that you have some basic background on the scope of Title IX's coverage, I'm going to turn things over to Carrie so she can talk with you about the theories of liability under Title IX when a student is sexually assaulted.
Thanks, Adele. Courts have recognized three basic theories of Title IX liability in the context of sexual harassment. The first is school liability for post-sexual assault conduct, meaning the school's conduct after a sexual assault occurs. The second theory is school's liability for pre-assault conduct. In other words, conduct of the school prior to the sexual assault of the survivor. And finally, courts have recognized Title IX liability for an official policy of discrimination. Next slide, please. Let's dig in a little deeper on each of these three theories so you can see how they play out in practice, and I'll use case examples to better illustrate what you should be looking for. So I'm going to start with post-assault Title IX liability, and I start with this because it's often considered the classic form of sexual assault, sexual harassment, Title IX liability standards. And the example I'm going to give is a case that is currently ongoing against Kansas State University, and I am representing these two victims, Tessa Farmer and Sarah Weckhorst, in a case against Kansas State University. Each of them, on separate dates and separate incidents, were sexually assaulted by fellow students at off-campus fraternity houses and events. So the fraternities were associated with the university, but they were not on campus. Kansas State took the position that because the fraternities were off campus, they were not under their control, and therefore they did not have an obligation under Title IX to investigate Sarah and Tessa's reports of sexual assault. So the conduct that we are attempting to hold them liable for in court right now is their failure to appropriately respond to their reports of sexual assault, their refusal to investigate their claims and take any action against the perpetrators, leaving these two women to attempt to get their education while facing their perpetrators on campus, in the classroom, and in the dorms. So just this week, the district court, the federal district court in Kansas, ruled that K-State did have sufficient control over the harassers and the context of the harassment, meaning over the student assailants, or the alleged student assailants, and their assaults that happened at fraternities. And they explained, the court explained that K-State recognizes those fraternities. Only K-State students are part of those fraternities. They have a Greek Affairs office that supports those fraternities with 5 staff members, that program is funded, and that in many, many ways they had control over those fraternity systems before and after the assault. So
in ruling that the court determined that Title IX does apply and that the university therefore did have an obligation to respond appropriately. So that whole question comes under this post-assault Title IX liability theory that after these students reported to the university, gave notice to the university that they had been sexually assaulted at fraternity houses, the university had an obligation under Title IX to respond. Next slide. The next theory of liability that student survivors can bring against their university are what I'm calling pre-sexual assault Title IX claims. So this is instances where before the student is sexually assaulted, before your potential client is sexually assaulted, the university conducts itself in a way that makes them liable under Title IX. So the example I want to give here is out of the University of Georgia, and it was brought by a former student named Tiffany Williams. So Tiffany went back to a dorm room or was in a dorm room at the University of Georgia having consensual sex, which she believed to be consensual sex with a fellow student. While that was going on, the closet door opened and another student popped out naked and began to sexually assault her. The first student got up and called another friend and said, "We're pulling a train on Tiffany," and he came over and also attempted sexual assault on Tiffany. It turned out that the University of Georgia had recruited one of those three students to the university to be a part of one of its athletic teams. And when they recruited him, they knew that he had a prior incident of sexual misconduct at that school, let him in anyway, and didn't do anything to warn or protect Tiffany or other students. The court determined that that conduct, the recruitment of the rapist despite knowledge of his prior sexual misconduct, constituted an act of discrimination. What I'd like to acknowledge is that in this case, the court also held the University of Georgia liable for their conduct after the sexual assault. So Tiffany very quickly dropped out. She was not doing well after this assault, and she dropped out. The University of Georgia took, I believe, 11 months to investigate the claim. And that delay, the court also found was an act of discrimination in the context of a post-assault Title IX liability. So while I'm dividing these into categories, you could certainly have both at an institution. Next slide, please. The third theory of liability under Title IX that courts have recognized is based on a school's official policy of discrimination. I'm going to use an example that came out also within the last few weeks out of Baylor University. And I chose to use it because I think the court really clearly laid out what an official policy claim looks like, and also because the types of things Baylor did, I've seen as typical of what might happen at a school that you might experience when you talk to survivors about their experiences at a university. So the court recognized a Title IX official policy claim where prior to the plaintiff's report of sexual assault, so before the assault occurred, Baylor's discriminatory practices in handling reports of sexual assaults, which included, 1, discouraging victims from reporting their assaults, and 2, failing to investigate their reports or punish the assailants, altogether constituted an overall official policy of intentional discrimination that in turn substantially increased the plaintiff's risks of being sexually assaulted. And the court in Baylor referred to that as a heightened risk claim. And I've seen it in general referred to as an official policy claim. And rather than just refer to a district court case, I want to highlight two, or just flag for you, 2 circuit decisions that also held schools liable under a official policy theory. And one is out of the 10th Circuit. It's Simpson v. CU Boulder, and the other is Hill v. Cundiff. I'm not sure if I'm pronouncing that correctly, but it's out of the 11th Circuit. And I'll add to the comments the citations for those two circuit court decisions. Next slide. I'm going to turn this back over to Adele to get into what the nitty-gritty of how to actually bring a Title IX claim and what is required to prove on behalf of the plaintiff.
Thanks, Carrie. There are 4 critical things that you should know about damages claims under Title IX. One, as I mentioned earlier, Title IX prohibits discrimination in programs that receive federal funds, and as a result, you can only assert claims against the recipient of federal funds. So at the K-12 level, this is typically the public school district or school board. And for private schools, colleges, and universities, this is typically a board of trustees. You can't assert Title IX claims against school officials or employees because they don't receive federal funds. The second critical thing to know about a Title IX damages claim is that a school can't be held liable for constructive knowledge of sexual harassment. It must have actual knowledge that a student experienced sexual harassment. The third thing is that schools can't be held vicariously liable for the conduct of the perpetrators. They can only be liable for their own misconduct in failing to respond appropriately to known sexual harassment. And fourth, a school's damages liability is generally limited to circumstances where it exercises substantial control over both the perpetrator and the context in which the sexual harassment occurs. And Carrie just talked about this a little bit. This would include situations where the perpetrator is another student, a school employee, or a third party permitted on school grounds or permitted to participate in school-sponsored activities. It would also include sexual harassment that occurs on school grounds, on the school bus, during extracurricular activities, or on school-sponsored trips. And as Carrie mentioned, it can also include sexual assaults that occur at fraternities. In some circumstances, schools may even be obligated to address sexual violence that occurs off campus or outside of school's education programs or activities. So, for example, if a student reports that she was sexually assaulted by another student off campus, but was later harassed by the perpetrator and his friends when she returned to school, a school may be obligated under Title IX to consider the off-campus sexual assault when determining whether action is needed to protect the student from further harassment or retaliation. And Carrie's going to say a little bit more about this later too. Next slide, please. So let's turn to the elements of a Title IX claim for damages. The seminal Title IX case on student sexual harassment is the U.S. Supreme Court's decision in Davis versus Monroe County Board of Education. In Davis, the Supreme Court articulated a 3-part test for establishing damages liability under Title IX. The plaintiff must prove that 1, the school had actual knowledge of the sexual harassment, 2, the school was deliberately indifferent to the sexual harassment, and 3, the sexual harassment was so severe, pervasive, and objectively offensive that it deprived the plaintiff of access to educational opportunities or benefits provided by the school. Now, needless to say, this is a high liability standard that's difficult to satisfy. In general, the successful Title IX cases involve egregious fact patterns, both in terms of the nature of the sexual harassment and the school's failure to respond appropriately. Next slide. So to satisfy the first prong of the test, the sexual assault must be actually known by a school official who has authority to take corrective action on the district or college's behalf. And this was made clear by the Supreme Court in the Gebser case, where the court first recognized a Title IX damages claim for teacher on student sexual assault. Officials with authority to take corrective action on a school district's behalf include the superintendent of the school district, administrators with significant personnel functions, school principals, and others such as assistant principals if they're given authority to impose discipline for sexual assault. Below the level of a school principal, whether a plaintiff may rely on the knowledge of another school official, such as a teacher or a guidance counselor, to establish liability is determined on a case-by-case basis. And FYI, this issue arises less frequently in the college context because survivors who report their assaults often will go to the school's Title IX coordinator, and that's sufficient for putting the college on notice. Next slide, please. So let's turn to the deliberate indifference prong of the liability standard. This is a subject of a lot of the Title IX case law. According to the Supreme Court in Davis, a school is deliberately indifferent when its response to sexual harassment is, quote, clearly unreasonable in light of the known circumstances, end quote. Well, what exactly does this mean? The answer is still evolving, but a few things are clear. First, there is no bright line rule on what constitutes deliberate indifference, and there never will be because it's determined based on the facts in each case. Second, it's clear that the standard does not require schools to take any particular disciplinary action against the perpetrator or to actually stop the harassment. So let me tell you about the facts in the Davis case because I think this will help give you a more concrete understanding of when a school may be liable for deliberate indifference to sexual harassment, including sexual assault. LaShonda Davis was harassed by one of her fifth grade classmates for 5 months until the perpetrator was charged with and pled guilty to sexual battery. The harassment included inappropriate touching of LaShonda, rubbing his body against hers in a sexually suggestive manner, and making sexually suggestive statements to her. LaShonda reported each of these incidents to her mother and classroom teachers. Her mother spoke with LaShonda's teachers and the school principal about the harassment, but the school did virtually nothing in response to these complaints. It never disciplined the harasser in any way. It didn't make any effort to separate the harasser from LaShonda. They continued to attend the same classes, and it took 3 months for her to get permission to change her classroom seat so she'd no longer have to be seated next to her harasser. Since the Davis decision, the lower courts have been grappling with when a school district has done enough to respond to harassment complaints and when it's acted with deliberate indifference. Some courts let school districts off the hook whenever they impose some discipline on the harassers, but others require more than this. So far, 3 federal circuits, the 2nd, 6th, and 11th, have interpreted deliberate indifference to mean that a school district must take remedial action that's reasonably calculated to end the known harassment. And under this interpretation, if a school district knows that its remedial efforts are ineffective, but it keeps using those same methods, then it's failed to act reasonably in light of the known circumstances. And let me give you an example of this so you know what this means in practice. Next slide. A good example of this is the 6th Circuit's decision in Vance versus Spencer County Public School District. The student in that case, Alma McGowan, was sexually harassed verbally and physically for 4 years until she withdrew from the school. The harassment started with peers verbally abusing her, calling her the gay girl and asking her to describe oral sex. And then the harassment escalated with male students harassing Alma and other female students by calling them whores, hitting them, snapping their bras, grabbing their butts. And the harassment increased to the point that Alma was propositioned or touched inappropriately in virtually every class. Alma and her mother complained to school guidance counselors, teachers, assistant principals, and principals, eventually filing a Title IX complaint under the school's sexual harassment policy. Well, what did the school officials do? For the most part, they merely talked to the offending students and never imposed any discipline. They didn't investigate the Title IX complaint, saying that they didn't have enough evidence to do so. And during the 4th year of Alma's harassment, her school provided sexual harassment training to all of its employees and did presentations on the topic for students. But the harassment continued and actually grew worse for Alma. Well, a jury found that the school district had acted with deliberate indifference to Alma's harassment in violation of Title IX and awarded her $220,000, and the 6th Circuit affirmed. The court specifically rejected the school district's argument that as long as a school district takes some action in response to sexual harassment, then it hasn't acted with deliberate indifference. And according to the 6th Circuit, the school district acted with deliberate indifference because it continued to use the same ineffective methods to no avail. Talking to the offenders produced no results. The harassing conduct continued and even increased. The court also found fault because the school district failed to investigate Alma's Title IX complaint, and the training provided during the 4th year of the harassment was too little too late. So when schools keep using the same ineffective methods to address campus sexual assault, you should use this evidence to argue that they've acted with deliberate indifference. And as Carrie often says, this argument boils down to Einstein's definition of insanity, doing the same thing over and over again, but expecting a different result. And I think that this is a very good way of making the point to a jury. Next slide, please. All right, let's turn to the third and final prong of the liability standard under Title IX. The plaintiff has to show that the sexual harassment was so severe, pervasive, and objectively offensive that it deprived the victims of access to educational opportunities or benefits provided by the school. The successful sexual harassment cases typically involve unrelenting harassment for a prolonged period that includes a physical component in addition to verbal taunting. But there are exceptions to this general rule that the harassment must be prolonged. For example, many courts have found that one severe incident of student-on-student sexual harassment, such as a sexual assault, may result in liability. And this is especially true when the school knew that the perpetrator had a history of sexual harassment, or the school's policies or practices made students more vulnerable to sexual assault, as Carrie was mentioning earlier. Even where the harassment's been severe, however, it's not actionable unless it denied the victim equal access to educational opportunities or benefits. So generally speaking, victims need to present evidence of adverse effects on their education, such as lower grades, having to withdraw from school, or that they're suffering from depression, anxiety, PTSD, or some other psychological disorder. Okay, now I'd like to turn this back to Carrie to discuss potential retaliation claims under Title IX, as well as other claims available to survivors under state law. Carrie, are you there?
Hello? All right, can you all hear me now? Yes.
Yes.
Excellent, thank you. I believe that many of the participants on this call are civil rights litigators in other contexts or may have some other sets of civil rights experience. And as many of us know, the issue that follows civil rights once you have them is retaliation for reporting those civil rights violations. In Jackson v. Birmingham Board of Education, the U.S. Supreme Court held that there is a retaliation component to Title IX. And as it was addressed earlier, Title IX damages claim is based on implied private right of action. So it's Jackson in which the court then held that retaliation against a person that has complained of sex discrimination is itself a form of gender-based discrimination that's actionable under Title IX. Next slide. So the retaliation legal standards that's been adopted by courts should look pretty familiar to folks that do employment discrimination. It starts with the plaintiff having to make a prima facie case of retaliation that has three components. First, that the plaintiff engaged in a protected activity. That's here going to be typically a complaint of sexual harassment. Second, that the plaintiff suffered an adverse action, a harm. So, for example, got kicked out of school for some reason. And third, there was a causal link between the two, meaning because they engaged in a protective action, there's a causal link to the adverse action. Then the burden shifts to the defendant to provide a non-retaliatory reason for taking that adverse action against the student. And finally, it goes back to the plaintiff to establish that the defendant's reasons are simply pretext for the retaliatory action. Next slide, please. So let's talk about what you might actually see when you're talking to survivors about the retaliation they face. And we wanted to talk about this because it is the experience of many survivors that after they report, say, a well-known football player for assault, or even a group of friends for some reason, that they face various forms of retaliation for speaking out. And often it can come against the student survivor in two forms. One is by the school itself, and another is by other students. And I'm going to talk briefly about a case that's going on at a Georgia high school that was featured in Slate that actually Adele and I are representing the victim and their family. And in this case, the young high school student was sexually assaulted by a fellow student on campus property. And she, the next morning, reported the assault to several people at her school, including their teachers, a school resource officer, and several other administrators. And within a few days, maybe 2 or less, the school punished her. They suspended her, and they charged her with violating the school's sexual misconduct policy for engaging in sexual activity on school property. It gets worse and worse from there, believe me. But I bring that up as a good example of, she engaged in a protected activity, reporting sexual harassment by a fellow student, and in response, the school, she suffered an adverse action, which was being suspended and charged, and there was a causal link between the two. Her complaint of sexual harassment is what led to that adverse action. Something she also experienced, and actually experienced this in this case because it became known that the school was holding her responsible for it. Other students decided that she was a liar, that she was a slut, and started to call her those types of names and other names in the hallways and online, and that compounded the trauma of, one, experiencing sexual assault, two, having your school punish her, and then three, having her peers retaliate against her. So sometimes that peer retaliation is considered a new form of basic sexual harassment, but it also could be considered retaliatory. Next slide, please. Before I turn it over to Adele, I'll just flag that retaliation claims also apply to teachers or coaches or other people who report sexual harassment or make a complaint of a protected activity, even if they're not the victim themselves, essentially because we want teachers and others to be able to report sexual harassment without risk of losing their jobs. All right, I'm going to go ahead and turn this over to, actually, I'm going to continue on, excuse me. I'm going to make a shift here from the sort of set of Title IX claims that we've been talking about to focus on other types of claims that you should be having an eye out for. We won't be able to go into these as in detail as we did Title IX, but I want to make sure that you're thinking about them as you evaluate a claim. So we're going to look at state-based claims that survivors of sexual assault in the school setting might have. So first of all, several states have their own anti-discrimination statutes that are parallel or similar to Title IX, but might have different standards. Or, for example, some might and some do expressly cover discrimination based on sexual orientation, gender identity, and gender expression. You can also have an eye out for state constitutional claims and state tort claims. So I'll go into these in a little more detail. Next slide, please. So I think the New Jersey Civil Rights Statute and the interpretation of it is a good example of a state sex discrimination and education law that has a better standard than does Title IX, the federal standard. So as you see in this slide, under the New Jersey statute, a school must address harassment about which it knew or should have known versus what Adele described earlier as actual knowledge required under Title IX. And then second, the school's conduct must take, the school must take action that's reasonably calculated to end the harassment. Compare that to the deliberate indifference standard that Adele described earlier. Next slide, please. I want to touch base on other torts issues that might come up as you're evaluating these claims. So these first two bullets, tort claims notice and damages caps, are going to apply potentially when you're evaluating state-based claims against public institutions. So some states have a Tort Claims Notice Act or Tort Claims Notice requirement, which requires you alert a certain body, maybe the school, maybe some other body, that you intend to bring a tort claim. And often that is a shorter time limit than is the personal injury statute of limitation that would apply to, say, the Title IX claim or to the tort claim that you're bringing. So you might have a 1 year or even a 180-day tort claims notice requirement, and if you don't file that, you could lose your ability to bring that claim. The second thing that you're going to want to look for is, okay, if I even am able to bring a tort claim against a institution, there might be damages caps. There are no damages caps on Title IX, but there can be various damages caps. So that can help you evaluate if it's the right path for your client. The next state-based claim I want to bring up is various negligence-based claims that you can look for in the K-12 context against schools and also in the college context against schools, but also are claims that you could bring against other entities, and the one I would highlight is fraternities. So in my practice, in addition to bringing claims against schools and universities, I often, because survivors are many times sexually assaulted at fraternities, often consider claims against fraternities, and these are vary from state to state, as Adele mentioned earlier, but premise liability claims is sort of the classic one. In the K-12 context, a negligent supervision or negligent hiring claim is also something you might keep an eye out for. University-owned housing at a private school is another place where you might get a premise liability claim. And then finally, this intentional tort is something to consider if the victim that you are representing is considering or interested in potentially bringing a claim against the assailant. And that's a personal decision for individual survivors to make, and you know, our job as attorneys, in my view, is to inform them about what that might look like and what it might mean. And one issue that can come up is the collectability on, even if one were to succeed on such a claim. On one hand, you can likely get punitive damages on intentional tort claims, but on the other, lots of the people in these contexts would not be able to, you could not recover from them. Sometimes, for certain conduct, a homeowner's insurance policy or a fraternity's insurance policy might cover that conduct, but typically not if it's framed as an intentional tort. I'm going to go ahead and go to the next slide, please. I'm going to turn this over to Adele to talk about another component of state tort law claims that is pretty significant to know as you're considering these.
Thanks, Carrie. So Carrie just outlined for you some of the potential tort claims on behalf of student survivors, but establishing liability can be challenging because of the obstacle of governmental immunity and the limited exceptions to that immunity under state tort law. And we don't have a lot of time here, so I just want to flag this for you. All 50 states protect public school districts and employees through some governmental immunity statutes. Most states don't provide blanket immunity to school districts and permit tort suits against both school districts and employees. But some states, such as Virginia, for example, bar any action against a school district or school board under the doctrine of sovereign immunity. In those states, the only tort claim would be against school employees. In addition, there's a federal statute called the Paul D. Coverdell Teacher Protection Act, which provides school officials with immunity from many negligence suits, instead limiting liability to situations where the harm was caused by gross negligence or willful misconduct, so a higher liability standard. The Coverdell Act allows states to opt out of its coverage, though. So if you're thinking about filing a negligence claim in a sexual harassment case, you should check to see if the Coverdell Act applies in your state. Because of governmental immunity issues, a lot of attorneys who litigate student sexual harassment cases focus on tort claims against private schools because then they don't have to deal with the immunity issues. Next slide. So now I'd like to shift to one more potential federal claim that student survivors may have. And in addition to a Title IX claim, survivors may have a sex discrimination claim under 42 U.S.C. Section 1983 for violation of the 14th Amendment's Equal Protection Clause. And as many of you may know, Section 1983 provides a private right of action for violations of rights secured by the U.S. Constitution and federal laws. It imposes liability on any person who violates a well-established constitutional right while acting under color of state law. School districts are considered persons within the meaning of Section 1983, so they can be sued for constitutional violations. But states aren't persons within the meaning of Section 1983, so state universities and colleges can't be sued for constitutional violations. Now, under Section 1983, you can sue state officials in their official capacity for injunctive relief, and you can sue state officials individually for damages, but you can't sue the state university or college for damages. Also, you can't sue most private schools under Section 1983 for constitutional violations because they aren't acting, quote, under color of state law. So, when I say that survivors may have Section 1983 damages claims for a school's violation of the Equal Protection Clause, I'm generally talking about claims against public school districts or claims against state and local school officials who are sued in their individual capacities. So let's turn to the Equal Protection Clause itself. The Supreme Court has interpreted it to grant people the right to be free from invidious discrimination in statutory classifications and other governmental activity. And basically, it prohibits governmental decision makers from treating people differently who are in all respects, relevant respects alike. And one example of this is treating people differently based on their gender. The Supreme Court has never ruled on the standards for establishing equal protection liability for student sexual harassment, but it has stated that they may not be wholly congruent with the standards for establishing liability under Title IX. And as a result, federal circuits differ somewhat on the standards that they apply in analyzing these claims. They all seem to recognize, that plaintiffs may establish intentional discrimination under the Equal Protection Clause by showing that a school district acted with deliberate indifference to the sexual harassment they suffered. But many circuits also require plaintiffs to show that a school district's discriminatory conduct was based on the plaintiff's gender. So, for example, if a school district ignores sexual harassment of females as routinely as it ignores sexual harassment of males, there may be no claim for sex discrimination under the equal protection standard applied by most federal circuits. Another obstacle to succeeding on equal protection claims is that the plaintiff will probably have to navigate two significant procedural hurdles that don't arise under Title IX: qualified immunity of school officials and municipal immunity of school districts. And because of time limitations, I'm not going to get into detail on this, but I just want to flag it as an issue. And let me say this, though, that because of these significant procedural hurdles, if the sexual assault survivor has a good claim under Title IX, it's worth evaluating whether the costs of also asserting a constitutional claim outweigh the benefits. Next slide, please. Sometimes it actually does pay off to assert both the Title IX and equal protection claims. And one good example of this is a case called Doe versus Forest Hills School District, where a district court in Michigan issued a great summary judgment decision allowing survivors' claims to proceed. The plaintiff in that case was sexually assaulted in 10th grade, and after reporting the incident to school officials, she suffered ongoing harassment by the perpetrator and other students, which is something Carrie was talking about earlier, is very common. The school didn't perform its own Title IX investigation of the complaint, and instead it waited on the results of a police investigation. It also failed to take measures to keep the assailant away from the plaintiff, and it failed to address the harassment that the plaintiff was suffering from her peers after she reported the sexual assault. Basically, the victim was socially ostracized by other students who thought she was lying about the sexual assault because no discipline had been imposed on the perpetrator. This is a lot like the case Carrie and I are involved in that she talked about earlier in Georgia. These facts present a really common scenario. Schools often fail to perform their own Title IX investigations and rely instead on police investigations. And students who report campus sexual assault often suffer subsequent bullying and harassment by their peers, particularly when schools fail to take any action to investigate the sexual assault or fail to institute any interim measures to protect the victim. In any event, the court, in this case, denied the school district's motion for summary judgment, holding that a jury could find deliberate indifference on at least 3 grounds. First, a jury could find that the school should have done more to address the ongoing harassment that the plaintiff suffered after she reported the sexual assault. Second, a jury could find that the school was deliberately indifferent because it limited its investigation, because of its limited investigation to the report of sexual assault. Where school officials are slow to act or investigate, then a jury can find deliberate indifference. And third, a jury could find deliberate indifference based on the failure to train school employees on how to respond to sexual assault complaints. And the court made a great statement about this that you should use in your own sexual assault cases. It said that, quote, just like failing to train a police officer on when to use his or her gun, failing to train a school principal on how to investigate sexual assault allegations constitutes deliberate indifference. And this is a great analogy. Given how few school employees receive adequate or any training on how to respond to sexual assault complaints, this is an argument you'll be able to use to establish deliberate indifference. And this will work for both Title IX claims and Section 1983 claims for sex under the Equal Protection Clause. In fact, both of those claims were present in this case. Next slide, please. I just want to say a little bit about the remedies that are available to student survivors of sexual harassment under federal and state law before opening things up to the Q&A. First, compensatory damages are available under both federal and state law. Verdicts and settlements in sexual assault cases generally range from 5 to 7 figures. And this is true whether the case involves claims under Title IX, state tort law, or other claims. The highest reported verdict we know of was $5.25 million in a state court case in Florida, where an 11-year-old raped a 7-year-old in the back of a transport van on the way to a public charter school and then raped her 2 more times in a school bathroom. The highest reported settlement we know of was a $5.75 million settlement in a federal case in Hawaii, where a gang at a public school for the deaf and blind sexually assaulted and terrorized their classmates for more than a decade. Punitive damages are not available under Title IX, and they're not available for constitutional claims against school districts or universities. But survivors can recover punitive damages for federal equal protection claims against school officials sued in their individual capacities. And sometimes punitive damages claims are also available under state tort law. And apart from damages remedies, plaintiffs who are still in the school district or at the university may seek declaratory and injunctive relief for Title IX and constitutional violations. So, for example, they may request new sexual misconduct policies and procedures, mandatory training and education for all district employees and students, tracking, reporting, and investigations of all sexual harassment, annual surveys on sexual and other forms of harassment, a properly trained Title IX coordinator, counseling for victims and perpetrators, and oversight by plaintiff's counsel. Obtaining injunctive relief is often the best way to force schools to make systemic changes that will reduce sexual violence. Finally, if you prevail on a Title IX or constitutional claim, you may recover attorney's fees from the defendants under 42 U.S.C. Section 1988. Many state anti-discrimination laws also permit the recovery of fees from defendants. Last slide, please. So before we get to the Q&A, and I know there's not a lot of time for this, let me just offer a few parting thoughts. Sexual assault cases on behalf of student survivors are difficult, to be sure, but they're extremely gratifying. Civil litigation can not only help compensate sexual assault survivors for the injuries they've suffered, but can help to change the culture of schools so they do a better job of preventing and responding to sexual violence. We are thrilled that you're interested in taking on these cases, and please don't hesitate to contact Carrie or me for assistance in your cases. We're happy to consult, and we have helpful resources to share. And in some cases, we may be able to join as co-counsel as well. Thanks so much for your time today. Let's open things up to the Q&A.
Hi, everyone. This is Alexandra. Carrie and Adele, thank you so much for this presentation. I feel like I learned so much, and I'm sure that the rest of our listeners did as well. We have a couple of questions from participants, and please feel free to send in others, though we are short on time. So the first question for you is there any way to know if a private elementary school receives federal funds short of discovery?
This is Carrie. One way to find the answer to that question that I've used is to call the U.S. Department of Education regional office and ask them. That's my suggestion. Adele, do you have others?
That's how I've done it too.
Okay.
I know there are some other folks who have looked into these cases, and they've gotten information even sometimes on the school's website, particularly about the federal free lunch program.
Awesome, thank you. So our next question is, do you think there's really a difference between the severe, pervasive, and objectively offensive standard for Title IX and the severe or pervasive standard applied in employment law?
This is Adele. I have not. I think there are some differences. I think that generally speaking, the severe or pervasive standard has been interpreted a little bit more generously under Title VII. But because under Title IX, you're seeing more and more courts treat that and as an or, such as when the harassment involves sexual violence. We're getting away from this being something that has to go on for a prolonged period of time. But because in cases that don't involve sexual violence, the harassment has to be pervasive and generally meaning prolonged, that's more stringent, I think, under Title IX than it would be under Title VII. But I'm sure there are some Title VII lawyers out there who have been doing this for years who might think that, it's just as stringent under Title VII, but I think it's worse under Title IX.
Okay, our next question is, what measures do you recommend taking to protect the client from being re-traumatized by the litigation or contact with the perpetrator of the sexual assault?
Well, I think those are two pretty different areas. So I'm going to talk briefly about the second, about the perpetrator, and say that a school's obligation under Title IX, if the two students are still in school together while you are bringing your litigation, or even if you're considering litigation and haven't done that yet, you have a lot of rights. So I do a lot of work to ensure that survivors can access their education without encountering their perpetrator, and that can come in the form of no contact orders or more stringent safety measures on campus. For example, I will say try to work with the school to set a rule around the times that the alleged assailant can, or the assailant can enter the library or enter the cafeteria, so that the survivor can go to those things without worrying about being with them, or ensure that they don't have classes together. So there's a whole lot you can do if you're worried about them encountering each other on campus. You can work with the school invoking Title IX to get a ton of protections for that student. As to the first question about being traumatized by the process of litigation, that's a tough one, and I think I try to be really upfront at the beginning of litigation around the challenges of keeping this issue top of mind and retelling your story, and having an institution that's going to be opposed to you throughout be part of the experience. So the focus of my practice is to make it an empowering practice, to say, despite what was done to you, you have rights. Those are guaranteed under the law, and we are going to fight back and give you a seat at the table to take charge and decide how you want to proceed, and do it from an empowerment perspective.
The only thing I'd add to that is that I agree with everything Carrie said. I think it's very difficult to avoid further trauma from the litigation, and that the best way to try and avoid that is to be really frank with your client about what the litigation process entails. Because if they're not prepared, then they are going to be traumatized. And even with the preparation, it's still going to be an incredibly difficult process. But it's very important that the lawyer inform the survivor what the litigation process entails, so they understand, what it's going to be like to have a deposition taken and be cross-examined at trial, and all these things that can happen, and they have to be ready for that. So they have to really make an informed decision about whether they want to proceed given what being involved in litigation entails.
We have a last question, and then just to be respectful of everyone's time, we'll wrap up. So the question is there any way to bring a a federal claim under a constitutional right to education?
A general claim like that, I have not seen those succeed. In fact, even the claims, generally like a substantive due process claim, a number of survivors have brought those claims, claiming that that the way the school responded to their report of sexual assault deprived them of their, liberty interests, and essentially their right to an education. I mean, that's basically what the argument is, that they're making their liberty to have an education in a safe environment. And those claims almost always fail. I have not seen, and they're failing more and more often. So I generally tell lawyers that are attempting to bring those claims not to bother. The equal protection claims are doing much better in the courts than any kind of substantive due process claim.
Okay, thank you. So we will wrap up. Before I hand this off to Nia to wrap everything up, I just wanted to again plug the Lawyers Network that we are building up here. Now that we are seeing both a rise in harassment and discrimination in schools in the wake of the election, and also can't rely on the federal government to enforce civil rights laws. Lawyers are needed more than ever in this space. And so we will be sending out a link to sign up if you are interested in representing students in sex discrimination cases, including sexual harassment cases. And we will be able to provide support and resources like this training to help you do so. So thank you all again, and I'm passing this off to Nia.
Hi, everyone. It's Nia. I just want to take one more quick moment and thank our panelists for doing such a fantastic job and sharing their expertise with us all. I also want to remind everyone that we are recording this webinar, and I will be sending everyone who registered for this event a recording that includes the PowerPoint slides and presentation, and that email will be going out in the next few days. But until then, thank you all so much for joining us. Thank you, Adele. Thank you, Carrie. And we can't wait over here until the next event. Thank you all for joining us. Bye.
Thank you.
Thank you all.